Welcome back to Taylor & Co. My name is Hazim Ashraf Hishamuddin, and I am joined here today with Audrey Ng and Amir Harris, and we will be discussing the key changes brought about by the Trademarks Act 2019. We will be beginning with a brief discussion on the meaning of a trademark, and this video will then discuss the significant changes towards the definition of a trademark, Malaysia's association to the Madrid Protocol, and various procedural changes made to streamline trademark law. Ultimately, it will be concluded that the Act has brought Malaysia's intellectual property law further in line with the international community. Now, before we begin, what exactly is a trademark, you might be wondering? Trademarks can be described as a distinct mark or sign which signifies to a consumer the origins of goods or services. The World Intellectual Property Organization, or otherwise known as WIPO, explains that trademark protection serves dual function, protecting the interests of both trademark owners and consumers. In terms of creator protection, trademark constitute a powerful marketing tool. As noted by Jong, Zainatu, and Ida, trademarks and brand share a close relationship whereby the distinctive character of a trademark plays a crucial role in allowing a brand to establish and maintain positive customer perception. Trademarks, being a form of intellectual property which can be bought and sold, also make up a substantial financial asset. Indeed, as noted by Jong, Zainatu, and Ida, intangible assets such as trademarks make up 80% of market value for America's largest companies. Hence, it can be seen that trademarks provide substantial utility for their owners. On the consumer side, however, trademarks law can be seen as a form of consumer protection. As indicated by the Intellectual Property Corporation of Malaysia, or otherwise known as MyEPO, trademarks serve an important function in empowering consumer choice. We as consumers have the right to rely upon the quality of the goods that we purchase, and trademarks protection allows us to do that just by linking a product or service to the origin and reputation of the company associated with the goods. Now, with these important functions in mind, it becomes important for nations to enact effective legislation to protect trademarks. At the opening of the legal year in 2020, as the then Attorney General Tan Sri Tommy Thomas expressed great enthusiasm at this development in Malaysia. He expressed hope that the enactment of the 2019 Act would achieve three main functions. Firstly, to provide a new and efficient regime. Secondly, to ensure that Malaysian trademark law is in line with the development of trademark law internationally. And finally, to further heighten Malaysia's compliance with obligations under international conventions. Now, Malaysia's previous Trademarks Act 1976 was enacted based on the English Trademarks Act 1938. However, England and Wales have long moved on from the Act in favor of a more modernized Trademarks Act 1994. Likewise, epicenters like the United States and the European Union saw expansive development in trademark protection law. However, up until 2019, Malaysia still relied on the rather dated 1976 Act. The Malaysian government finally sought to change this with the enactment of the Trademarks Act 2019, intending to bring Malaysia's trademark protection laws level in line with the international plane. To start off the discussion regarding the changes brought about by the Trademarks Act 2019, as well as its significance, I would like to invite Amir Harris.
Thank you, Ashraf. Among the major changes brought about by the Trademarks Act 2019 is regarding the scope of recognized marks. When trademark registration systems were first introduced in the 19th century, only a handful of registrable marks were available. These usually comprised of words, letters, numerals, and logos. Indeed, this is what was reflected in Malaysia's 1976 Act, which recognized marks as being made up of words, letters, numerals, etc. However, as noted by Leah, the range of registrable subject matter within the US and EU quickly grew past these confines. Eventually, it was recognized that trademarks could potentially go beyond logos, words, and numerals, and could be extended to other distinctive features such as the color of goods in their packaging, three-dimensional shapes, and even non-visual features such as sound and scents. These are referred to as non-traditional or non-conventional marks. Malaysia's Trademarks Act 2019 reconciles Malaysia's position with that found abroad. The definition of a mark under the previous act has now been replaced with that of a sign. This definition retains the previous categories, but adds to them other newly recognized categories, such as the shape of goods in their packaging, colors, sounds, scents, holograms, positionings, and sequences of motion. What this effectively equates to is express recognition that non-traditional marks are recognized as capable of forming a trademark under Malaysian law, thereby putting Malaysia in a similar position to the United States and European Union. This presents a significant change in that distinctive colors such as Cadbury Chocolate's signature deep purple color, or the ever-memorable Roaring Lion sound clip used by MGM Studios, can now be registered as a trademark in Malaysia, subject to the requirements of distinctiveness and graphical representation under Section 3 of the Act. Notwithstanding this apparent extension in the scope of protectable signs, however, it appears that protection of certain categories of signs, in particular scents, remains unavailable. The reason for this lies in Section 3, subsection 1 of the Trademarks Act 2019, which requires a sign to be graphically represented before being capable of trademark protection. As the Trademarks Act 2019 is still in its infancy, the courts have yet to consider what graphical representation entails. However, the Court of Justice of the European Union offered its views as to what amounts to graphical representation in the case of Sickman. Here, it was held that the graphical representation of a sign must be clear, precise, self-contained, easily accessible, intelligible, durable, and objective. In Sickman, the claimant's deposit of various articles in an attempt to graphically represent a scent was ultimately unsuccessful. The court considered the deposit of an odor sample as not being sufficiently objective or durable. Similarly, the odor description provided was also not sufficiently clear, precise, and objective. Finally, the chemical description and formula provided only related to the substance as such, and not the odor coming from it. Hence, the scent sought to be trademarked failed. It can therefore be seen that the evidential threshold for graphical representation is a high one. Though it has been settled in Europe that certain non-traditional marks, such as color and sound, can be sufficiently graphically represented, this has yet to be done for scents. The key difference here appears to be the presence of a universally accepted and objective standard. Colors can appropriately be represented with the use of the Pantone scale, while sound can be illustrated through musical notes with bars, clef, notes, and rests that show the full pitch and duration of the sound. The same standard is absent when considering scents. Applying the view offered by the European Court to the Malaysian Trademarks Act 2019, despite scents being included in the definition of a sign under Section 2 of the Act, it is doubtful that it will ultimately satisfy the requirement of graphical representation under Section 3, subsection 1. Hence, it is likely that scents remain unregisterable as trademarks in Malaysia. It is argued that this is the main aspect in which the Trademarks Act 2019 requires improvement. It seems incongruous that the Act specifically allows for scents to be recognized as a sign, but also subjects it to the need for graphical representation in order to be recognized as a trademark, thereby rendering scents de facto unregisterable. As Ramsey points out, there is significant incentive for this to be remedied, as sensory trademarks such as scent, taste, and texture have been shown to be effective in conveying a strong brand message and attracting and retaining customers. As noted by John, Zainatul, and Ida, sensory branding is poised to only grow in importance in the future, with the rapid expansion of business and e-commerce innovations. Legislation in the EU has already repealed the need for graphical representation, replacing it with the requirement of representation through any technological means available. Though a standard for representing scents has not yet been agreed upon, it is argued that Malaysia should follow in the EU's footsteps in replacing the need for graphical representation with representation through available technological means. This would be a suitable preemptive measure in anticipation of establishing a universal standard for representing scents, tastes, and textures. Doing so would also bring Malaysia's trademark law more in line with the spirit of Article 15 of the Agreement on Trade-Related Aspects of International Property Rights, which suggests that the deciding factor for registrability should not be whether a mark falls within a traditional or non-traditional category, but rather whether they are capable of possessing a distinctive character. To explore further the changes brought about by the Trademarks Act 2019 regarding the registration process of a trademark, I'd like to welcome Audrey.
Thank you, Amer. The next significant changes brought about by the Trademarks Act 2019 are in relation to the registration process. Firstly, trademark owners can now register their trademarks in multiple classes prior to the 2019 Act. A proprietor of a trademark will need to file multiple single trademark applications to protect his trademark in multiple classes. For instance, a proprietor producing a medical apparatus and materials seeking trademark protection in both Class 10 and Class 5 will need to file two separate applications. With the new Act, however, multiple class applications have now been made available under Section 18, with a proprietor being able to file his trademark in up to 3 classes without the need for separate applications. This change therefore significantly improves administrative efficiency in line with the objectives of the Act. Aside from that, the examination procedure has since been redesigned to promote better legal clarity. In particular, the grounds for refusal has seen a substantial overhaul compared to the old Act. Previously, this was covered by Sections 14 and 15 of the 1976 Act. Notably, these provisions created confusion as they merely provided for various circumstances where registration may be refused, but did not make any distinction as to what constituted absolute grounds for refusal and what refusal was merely relative. The new Act remedies this by expressly particularizing the grounds for refusal. Section 23 lists out absolute grounds. So these are situations whereby there are inherent defects in the trademark, such as being devoid of any distinctive character or being unable to be graphically represented. Section 24, on the other hand, discusses relative grounds for refusal, which lists out circumstances of refusal which are based on comparison with other existing trademarks. So for example, a trademark can be refused on relative grounds if it is found by the registrar or to be identical or similar to an existing trademark in the same or similar class. Such categorization into absolute and relative grounds mirrors the changes made by the UK in the Trademarks Act 1994, and, as explained by Zhong and Zadato, provides heightened legal clarity. It must also be noted that the Trademarks Act 2019 also brings with it new grounds for refusal. These added grounds mirror those implemented in the United Kingdom and European Union. For instance, Section 23, Subsection 3, which makes clear that shapes resulting purely from the nature of goods are necessary to obtain a technical result or add substantial value to the goods constitute an absolute ground for refusal. This mirrors the position in Article 4 of the European Trademark Regulations. Likewise, Section 23, Subsection 5G of the 2019 Act, which provides for that trademarks bearing a flag of a country, national emblem, insignia, or royal arms cannot be registered without the permission of relevant authorities, is also pari-material to both Article 6 of the Paris Convention, and bears a strong resemblance to the position of England and Wales under Section 4 of the Trademarks Act 1994. Finally, the Trademarks Act 2019 also makes available the system of international trademark registration under the Madrid Protocol. The protocol operates to establish a system of international registration in over 122 member countries. Section 75 of the Trademarks Act 2019 was enacted to make registration under the protocol available. The effect of this is that trademark owners can now protect their trademarks in all member countries simply by filing one single application in one language and by paying one set of fees. This significantly conveniences both Malaysian individuals and companies seeking to expand their businesses internationally, as well as foreign companies seeking trademark protection in Malaysia. Simultaneously, it also brings Malaysia's trademark law framework on par with the EU and the United States. It can therefore be observed that the significant improvements have been made to the registration process under the Trademarks Act 2019, including the availability of multiple class registration, increased clarity on the examination process and grounds for refusal, as well as the establishment of the international registration under the Madrid Protocol. That's all from me for now. I would now like to pass the time back to Ashraf to talk about the next significant change the Trademarks Act 2019 has brought.
Thank you very much for that, Audrey. Now, the Trademarks Act 2019 also brought about changes which brought trademarks more in line with the proprietary nature of intellectual property. In particular, the new Act now allows for trademarks to be subject to a license and a charge. Previously, the licensing of a trademark was not provided for under the 1976 Act, and the only method of conferring rights to use a trademark was by way of assignment and transmission via Section 55 of the 1976 Act. These, unlike licensing, permanently confer the exclusive right to use a trademark to the assignee of a person to whom the trademark was transmitted to. Conversely, licensing is a temporary transfer of rights. Michael Spence notes that the previous unavailability of trademark licensing in England and Wales may have been for the purposes of preventing misrepresentation or fraud on the public. However, and in line with the growing recognition of trademarks as a form of valuable property, licensing was made available through Section 28 of the Trademarks Act 1994. Malaysia has since followed suit with Section 69 of the Trademarks Act 2019, making licensing of a trademark expressly available, and Section 7T now conferring a licensee with exclusive rights over a licensed trademark. A licensee would be able to call upon the registered owner of the trademark to bring an action on his behalf in cases of infringement, failing which the licensee would be entitled to bring an action in his own name. Aside from that, trademarks are now also recognized as a personal or movable property for the purposes of creating a security interest. This means that individuals and companies may use trademarks for the purposes of creating a charge in exchange for finance. Companies which do so are required to register the charge pursuant to Section 353 of the Companies Act 2016. Hence, both of these changes present significant improvements to the status of trademarks as a form of valuable property. Now, I'll turn the floor over to Audrey to discuss the new trademark enforcement measures introduced under the 2019.
Thank you once again, Ashraf. Lastly, it should be mentioned that the new Trademarks Act 2019 also provided enforcement measures against violators of the Act. Previously, under the 1976 Act, no provisions could be found for criminal offences or penalties for counterfeiting and infringement activities. Instead, this was governed under the Trade Descriptions Act 2011. This act was an act that dealt with false trade descriptions in a rather general manner and was not specifically concerned with regulating trademarks. As noted by Ling and Wong, the Trade Descriptions Act 2011 was an important piece of legislation prior to the Trademarks Act 2019. This is because it provided for the administrative enforcement of trademarks and criminal penalties for infringement. The 2011 Act also prohibited the application of false trade descriptions in relation to trademarks. Section 8, subsection 1 expressly included the use of a registered trademark into the definition of a trade description. The acts of falsely applying, supplying, and exposing for supplying goods bearing a false trademark was suspect to criminal actions pursuant to Section 8, subsection 2. However, and as noted by Jong and Zanatu, the 2011 Act was largely perceived to be an overly onerous on claimants seeking to enforce their rights. Firstly, the separation between trademark regulation within the Trademarks Act 1976 and trademark enforcement under the Trade Descriptions Act 2011 caused significant confusion to prospective claimants. This was only compounded by the additional consideration of common law principles, such as passing off. There was also the requirement for a trademark owner to apply to the court for a trade descriptions order pursuant to Section 9 of the 2011 Act before filing a claim for the infringement. This caused both delay and heightened cost of procedure. The Trademarks Act 2019, however, provides a unified avenue for civil and criminal offences. Indeed, Part 15 of the Act now replaces the Trade Descriptions Act 2011, providing for criminal offences for counterfeiting and falsely applying a registered trademark. Activities relating to the distribution of infringing articles, such as the making, possessing, importing, or selling of goods which bears false trademark, are also similarly criminalized. Express recognition of the common law rules surrounding passing off were also expressly retained under the new Act, providing it with express recognition and thereby ensuring legal clarity. The requirement for application to court for a trade descriptions order has now also been removed. The remedies for infringement, which the court is entitled to grant, are also clearly listed out in Section 56 and includes injunctions, damages, and account on profits, echoing the position under Section 14 of the English Trademarks Act 1994. This provided additional clarity as the remedies available were previously governed by case law. Therefore, as noted by Zhong and Zanatu, the 2019 Act provides significantly heightened simplicity and clarity to the enforcement of trademarks in Malaysia. The consolidation of the enforcement measures and penalties into one Act allows for enhanced clarity of the law, thereby making it simpler for claimants to enforce their rights. Further, the express recognition of the validity of damages, injunctions, and an account on profits brings Malaysia's trademark regime further in line with its obligations under Part 3 of the TRIPS Agreement on intellectual property enforcement. Hence, the inclusion of enforcement measures into the new Act certainly brings Malaysia more in line with international standards, as well as heightening its compliance with TRIPS.
Thank you very much for that. Now, to summarize our group's discussion, the Trademarks Act 2019 added 4 major changes to the legal regulations surrounding trademarks in Malaysia. Firstly, it expanded the scope of trademarks. Secondly, it generally simplified the registration process. Thirdly, it improved the status of trademark as a form of intellectual property. And last but not least, it implemented the enforcement of measures for false representation of registered trademarks. Based on the above, the changes towards the registration process, the proprietary status of trademarks, and enforcement mechanisms have brought about clear positive developments in improving the efficiency of the trademark regime and bringing trademark law in Malaysia further in line with international standards. Significant strides have also been made in heightening Malaysia's compliance with international conventions. However, the need for graphical representation under Section 3.1 of the Act significantly curtails the expansion of the scope of trademarks in Malaysia. It is therefore suggested that this requirement is removed and replaced with the requirement of representation through any technological means available.